Welcome friends. In our academic pursuit, let us have a discussion about leading to discovery. Leading to discovery is a step forward for investigation in a criminal case, and the provision has been embodied in section 27 of the Evidence Act. Leading to discovery means it is a process of collection of evidence from the statement of accused. It is a piece of circumstantial evidence, and when direct evidence is not available as a circumstantial piece of evidence, if evidence collected during leading to discovery is linked with other circumstantial evidence and a chain is complete suggesting guilt of the accused, a conviction can base against the accused. So leading to discovery means collection of evidence through statement of the accused. So the first and foremost requirement in the process is that the accused is in custody of the police officer conducting the investigation. The custody may be without a formal arrest or before the arrest, after the arrest, or during the period of police remand. That means when the accused is remanded to police custody by the court. So in all these situations, it can be held that the accused is in police custody. Normally it is advisable that the process of leading to discovery should be initiated whenever the accused is in custody of a police officer after his arrest or after his remand to police custody by order of the court. The entire process of leading to discovery consists of three parts. First part is recording of disclosure statement of the accused. When the accused volunteers before the investigating officers while being in his custody that he will make certain revelations out of his own volition, the investigating officer will call at least two independent witnesses, and in their presence the statement of the accused shall be recorded. And after recording the statement, the same shall be read over and explained to the accused in presence of the witnesses, and he will put his signature on the said statement prepared by the investigating officer. And then the witnesses present will also put their respective signatures in token of their acknowledgement that the statements are recorded in their presence, which was made by the accused voluntarily. This is the first part. And after preparation of the disclosure statement, yes, I think it proper to mention that this disclosure statement can never be treated as a confessional statement of the accused, because law prohibits that no confession of an accused can be recorded by a police officer, and if so recorded even, it will be hit on section 25 of the Evidence Act, it will have no evidentiary value. So this disclosure statement is not the confessional statement of the accused. This is the statement from which some new fact which is within special means of knowledge of the accused is likely to be discovered. So after recording this statement, if it appears from the statement that certain material, certain article, or even a dead body or any other thing connected to commission of the offence is concealed or disposed of by the accused, and the accused is willing to lead the police team and the witnesses to that particular place and to give recovery of the same, then the investigating officer and the witnesses will accompany the accused to that particular place wherefrom the materials, if discovered at the instance of the accused, shall be seized by the investigating officer. So first is the recording of the disclosure statement, second is leading of the accused to the concerned place, and the third step is preparation of the seizure list. The incriminating materials, if found at the instance of the accused, all such materials will be seized by the investigating officer by means of seizure list, and in the seizure list the accused as well as the witnesses will put their signatures. The circumstances of seizure will be properly recorded, that under what circumstances such seizure has been effected by the IO. So the statement of the accused leading to discovery etc. will be duly mentioned in the seizure list in the circumstances of seizure column. Here one question arises, whether the same set of witness will be there at the time of preparation of the disclosure statement as well as at the time of seizure, or new set of witnesses can be mentioned in the seizure list if the witnesses present at the time of disclosure of the accused are not present. In this situation, it is advisable, it is better to ensure presence of the same set of witnesses at the time of disclosure statement of the accused and at the time of seizure, because it would inspire more confidence in the mind of the court that the witnesses, whoever heard the statement of the accused, they are also present at the time of seizure of the incriminating materials at the instance of the accused. That would more strengthen the doctrine of confirmation. This is called the doctrine of confirmation. Whatever is stated earlier by the accused is confirmed when certain materials are seized. This is called doctrine of confirmation. So it is better that the same set of witnesses are there in both the events. If at all the witnesses present at the time of recording of disclosure statement of the accused are not present for certain reasons at the time of seizure of the materials at the instance of the accused, then the same thing can be recorded in a note in the case diary that for such and such reason the witnesses who had the disclosure statement of the accused could not remain present at the time of seizure of the materials at the spot. So recording of the reason would more authenticate the process of leading to discovery. It is better that the entire process of leading to discovery is videographed. Although it is not mandatory, it would be better to establish the voluntary act of the accused that he disclosed, he led the team, and he gave recovery of the things. One problem always arises while interpreting the concept of leading to discovery, that whether the place from which the material was discovered, whether it was an open place, that means publicly accessible or not. If the place is an open place or it is having public accessibility, then many times the courts interpret that leading to discovery is not sufficiently proved, because everybody is having accessibility to that particular place. But in some cases, it has been interpreted by the courts, even by our apex court, that public accessibility and public visibility should be distinguished. One place is publicly accessible, a field is publicly accessible, but if something is kept under a bush in the field and it is not publicly visible, then leading to discovery suffices. No fault can be found with the leading to discovery if anything is seized from a place, even if it is publicly accessible, is not publicly visible. Another important issue that happens in many cases, after the disclosure statement of the accused is recorded and he leads the team, investigation team and the witnesses to a particular place, but nothing is found at the place. In that scenario, we cannot say the entire proceeding of leading to discovery is rusticated because nothing is found. Even nothing is found, if that particular place of disposal or place of concealment is shown to the investigating team, then the investigating officer will prepare a memorandum because he has nothing to seize. So no seizure list is required to be prepared there for non-availability of any incriminating material. But here he will prepare a written memorandum that by disclosure of the accused, he accompanied the accused being led by him to the place along with the witnesses, and nothing is found in that place. Even nothing is found, that particular place since discovered by the statement of the accused, which was within his special means of knowledge, it also amounts to leading to discovery. Anything which is found by means of leading to discovery or seized by means of leading to discovery are required to be sent for a scientific examination, considering the fact and circumstances of the case. If it is a weapon of offence in which blood is stuck, or if it is a dead body, then their medical legal examination is highly essential. Similarly, if any wearing apparel of any person is concealed, having blood stains, then the same is also required to be sent for scientific examination. So, in the process leading to discovery is having a much higher evidentiary value if properly conducted. Even in many cases, the apex court has held that the independent witnesses to the leading to discovery, they may turn hostile, but basing upon the evidence of the investigating officer, if leading to discovery is duly proved, then it will be sufficient to fetch a conviction against the accused. So much credibility being attached to leading to discovery as an important piece of evidence, the documents should be prepared with much care and caution so that the investigation will be properly proved in the court and the offender will be punished. Thank you.